You've written a paper on something known as truth decay. What is the risk of truth decay? And in Australia, do judges and courts need to be worried about it?
Yeah, so I've used this example of the US, the perception of apparently millions of people in the United States that the 2020 election was stolen, where over a dozen senior courts have ruled that it wasn't. And the concern I've pointed to is twofold. Either those millions of people are not aware of what the courts have said and the significance of what the courts have said. They're either ignorant of that, or not being ignorant of it, they don't accept it. Either explanation is a cause for concern. So it's very important that in a democracy, courts are not only independent but are respected by the community, that their work is known and their decisions are respected as having been arrived at as a result of a systematic, fair hearing presided over by a judge whose independence is guaranteed by security of tenure, not influenced by political concerns, not influenced by financial concerns, etc. We have to be constantly vigilant that the courts in this country have and continue to command respect in the broader community.
Also in that Truth Decay paper, you have discussed the rise of generative AI. Is AI's risk in terms of the court's perspective, is it mostly around the admissibility of evidence, or are there other problems there?
AI, and particularly generative AI, raises a huge number of issues for the legal system as well as society more generally. One obvious issue is what are called deep fakes. Now, we've always had forgery in the courts. There's always, courts have over hundreds of years had to deal with examples of forged evidence, forged signatures, fabricated documents. But the power of AI, including not just documents but mimicking voices, etc., presents huge opportunities for fraud or attempted fraud. So we need to be vigilant about that. But there are a number of other issues. For example, expert reports in complex matters. AI offers the ability to interrogate vast databases of material and to generate reports, generate answers. But of course, the courts need to understand the reasoning behind conclusions, etc. And that's a matter which we need to be conscious of and careful about. We need to be conscious of practitioners using generative AI. We know generative AI can produce what are called hallucinations, which are, in a sense, false answers or fabricated answers, creating case law which doesn't exist, etc. So that's something, again, which courts and practitioners need to be not only vigilant about, but need to take responsibility for. That's not to say that it's all bad. There will be some areas where generative AI will be of assistance within the legal profession and in a sense, with research tools. So we have to be careful not to take a reflexive, hostile attitude to it, but it's extremely complex, both at a practical level, but also raising some more philosophical questions.
The admission of women to the legal profession was barred in New South Wales until 1918, and we can see in the cases handled by the court that the societal attitudes were changing. But we didn't have our first female judge of the Supreme Court until Jane Matthews in 1987, so that was some 160 or more years after the court was created. Why did that take so long?
Well, not only was it 160 years after the court was created, it was almost 70 years since legislation was passed, the Women's Legal Status Act, which entitled women to practice law, to be appointed as judges, to go into Parliament, etc. So even with that legislative change, there was this huge delay. Jane Matthews was a trailblazer. She was one of only 2 women in her year at law school in the late 1950s. She was the first female Crown prosecutor. She was the first female district court judge, and she was followed on the bench by Justice Carolyn Simpson, Justice Margaret Beazley, now our Governor, Justice Virginia Bell, Justice Paddy Bergen, and many others since. So it was a long time coming, but now about a third of the Supreme Court bench is female. In New South Wales and the New South Wales judiciary overall, we're about just under 45% of judicial officers are female. So there's been, in the last, I would say, 15 years, a major shift in terms of the gender composition of the bench, and that is all good. It's been a very salutary development.
We're sitting right next to this incredible history wall. There are some amazing historical figures in there and moments in time, and particularly some incredible trailblazing women who were part of the legal profession and still are. There was a school group in here just before we started speaking. What would you want somebody who's looking at this wall to think as they reflect on the last 200 years?
You mentioned the school groups, and that one of the whole philosophies of creation of a history wall and the creation of a gallery of images from the court's history has been that educative one I've spoken about. What I hope that the history wall and the gallery bring out is the richness of the court's history, its significance and central role in our society over the last 200 years, that it's often been at the centre of social change, of resolving disputes, whether they be in the criminal law or on the civil side. But particularly with the gallery, we've sought to gather a very eclectic set of images of people and events. My philosophy or my view is that courts are involved in a very human process. For any litigant, the case is often of huge significance to them personally or their families. It might affect a question of liberty, property, it might affect their children, it might affect their financial position, etc. There's great human drama, as you know, in the courts. And part of the role of judges is to resolve those disputes fairly and systematically, but also sensitively. So the pictures, the images which we've surrounded ourselves with seek to capture some of that essential humanity of the process. That I think is valuable.
Just finally, looking ahead into the court's future, what are the biggest challenges for justice, and how do you think the court will continue to evolve?
One of the challenges we've already mentioned, that's AI, particularly generative AI, which is becoming more and more powerful as the scientists refine and constantly improve that technology, and that is one of the immediate challenges for the court, how to deal with the myriad issues that promotes. One of the things we have to be sort of constantly vigilant about is maintaining the independence of the judiciary. That means having strong appointments to all levels of the judiciary, providing sufficient support to judges, having enough judges to deal with the many disputes in our community. I mean, it is the fact that there is, I think, about roughly 340 judicial officers in New South Wales, the Supreme Court, the District Court, the Land and Environment Court, the new Industrial Court, and the local court. So the number of judges has grown over the years, but there are always budgetary pressures, etc. So, but we have to insist that the judiciary continues to be properly funded and supported so it's able to do its job. and that is in the community's interest. A small number of people are doing very large amounts of very important work.
Chief Justice, it's been a pleasure speaking with you. Thank you so much.
Thanks very much. Thanks for the time.